Today we walk into an amusement park and there are signs everywhere. The lists in front of attractions at the major theme parks is insane and getting longer and longer all the time. A lot of times these rules come from lawsuits. But to understand how we got to where we are today, we have to look back at what got us here. 100 years ago, there was a case called Murphy and Steeplechase Amusement Park on Coney Island. By today's standards, amusement parks started out really simple, but were quite dangerous because of that simplicity. You'll see no ride restraints, people flopping and flying all over each other. At modern amusement parks, the biggest thing is to prevent people from falling, but that was just the ride back then. Between 1897 and 1964, the Steeplechase Amusement Park operated on Coney Island. It wasn't the most respected of places. It was considered dangerous, erotic, and alien to the public. And that was reflected in the decisions handed down by the court at that time. The attractions of that time were designed to show flesh, be risque, throw women into men's arms. We famously know that when Walt decided he was going to get into the amusement park industry, Lillian was not that impressed, asking him why he wanted to be involved in something so cheap and dirty. We know that Walt wanted to create a place for the family. And it's kind of ironic how over the years, especially in the most recent years, the amusement park has started at a place that was unsavory and now has become a place for the elite, especially with the modern prices at Disney World. That demonstrates how far theme parks or amusement parks rules have come in the last more than 100 years. In 1925 at Steeplechase Park on Coney Island, there was a ride called Flopper. And the thing about this ride is it ended up making legal history. What happened was a young man, around 19 years old, sued Steeplechase Amusement because he fractured his knee on the ride called Flopper. Essentially, going with the simplicity of the attractions at the time, Flopper was a conveyor belt that went upwards at a 5-foot incline at around 7 miles per hour for about 50 feet. The whole point of the ride is in the name. People were supposed to fall and get off balance and knock the next person over. Murphy was the plaintiff in this matter, and he testified that he got on the ride, and as he was stepping on, it jerked and stopped when it wasn't supposed to, and he fell and broke his knee and was in the hospital for a month afterwards. Even at the time that the case went to court, he was still limping, and this was more than a year later. Murphy argued that the ride run by Steeplechase Amusement Park was dangerous to life and limb. By today's standards, obviously. But in 1925, 1926, not so fast. The judge at the time determined that this was not the case, that the ride was perfectly safe, and it was the way that Murphy had conducted himself was the problem. He should have seen that falling was a risk, and he just got unlucky and broke his knee. Academics claim that there were undertones in the way that the case was written that suggests the judge, a hoity-toity of the time, was wondering and making a decision with a disdain for both the plaintiff, Murphy, and the defendant at Steeplechase Amusement Park. Why would anyone even go there? And that's unfortunate because the court's not supposed to take that approach. They're supposed to be neutral and not bring their own values into their decisions. If you learned something today and made it to the end of the video, I hope you subscribe, or if you're not already, leave a like, comment, what do you think?